Good evening, everybody. Attorney Greg Lake here with my good longtime buddy, partner in crime as always, Buddy Bear. Welcome to the Entheogenic Esquire podcast and YouTube channel. God bless each and every one of you. Thank you, Miss Susan, in the chat. Please like, subscribe if y'all have the bandwidth today. It'd be very much appreciated. As advertised, I will also be with Adam Thomas of the Adam Thomas podcast tonight. He is finishing dinner with his family. He will be here shortly. I will hold court until then. So again, very grateful for everyone here. I see my ride or dies are in the chat. God bless each and every one of you. I will give y'all a shout out here in just a little bit, but we'll jump kind of right into it. Well, let me just say this before we start. If it's true that Thomas Massey lost his election, my heart's a little broke, but we'll talk about that at the end. But anyways, yeah, we'll just go ahead and kind of jump into it. Obviously tonight, as advertised, we're here to speak about the Tyler Robinson hearing that was today. This was a hearing started early morning their time, 9-10 o'clock. It was about a 2 to 3 hour, not it was like right a 2 hour hearing. Today they really covered two main issues. One of them I'll talk about a little bit more in depth than the other. But the first issue was the defense filed a motion and is seeking to hold in contempt of court civilly the DA's office, and particularly one district attorney by the name of his name is Mr. Ballard, Christopher Ballard. So Christopher Ballard is a member of the DA's office, part of their team, and apparently after the defense filed a motion to extend the preliminary hearing, right, or a motion for continuance to continue the preliminary hearing. Within that motion, they discussed evidence related to the ATF report, right, because their inability to test that report on top of other issues, right, but their inability to appropriately get, expert testimony, expert review, and ability to effectively cross-examine the experts, right? They're asking for an extension of the preliminary hearing, which has now been set sometime in July. But anyways, in response to that, okay, now obviously the state, the DA, they did file an actual response to that motion in the record. But they also drafted, apparently they had some internal conferences, and we'll talk about that in a little bit, but they drafted some emails to go out to the media, and then Mr. Ballard actually went and spoke to the media, I think from my impression on several counts, but in particular, as we'll talk about in a minute, there were a couple live interviews, I believe one on Fox, maybe on one, it was, and I just quoted it earlier on X Post. The other was in U.S. Today, I think, the publication. So was all right. U.S. Today. Yeah, USA Today. I'm sorry, not U.S. Today, USA Today. Anyway, so, and I'll talk about the substance of these, press interviews here in a minute. But anyways, that was within those statements, and I'll talk about the rules also in a minute. The defense alleges that those statements violate the court's original, remember, at the very first this case, because of the whole media, pardon my language, shitstorm, right? The court put the official standing and decorum order seeking to regulate, and I think part of it was also a gag order as well, seeking to regulate the First Amendment rights, particularly, again, I don't want to phrase it like that. He sought to regulate First Amendment rights, but, set in order regulating, who can disclose what in terms of witnesses, parties, but more specifically for our purposes, attorneys. And as we'll see in a second, judge actually adopted some language from the model rules of professional conduct to insert into this order regulating the certain types of speech or remarks that attorneys, in this case, Tyler Robinson's case, extrajudicially, right, outside the courtroom could and could not make, okay? And obviously, I'll just say this at the outset. Hey, Daisy, thank you very much. God bless you. I appreciate I'm blushing. Anyway, I guess I'll say at the outset, obviously, this is a very intense, it's an intense case, right, all the way around. But let's just highlight for a minute the intensity and the breadth and just insanity of the media coverage, right? And particularly there's good media coverage. Hey, like this live stream right here. And, we got Baron Coleman and Candace and Danks and all these people. But, obviously there's some bad media out there, right? Fox News. And again, this is just my opinion, just expressing, Newsmax, these people. Anyways, it's a storm, right? It's a storm of all sorts out here. And, so in that environment, and the reason why I wanted to start out with this, because I felt the prosecution a little bit today. Like, I do understand in a sense that, like, we have this media storm, and, the media has been misconstruing a lot of stuff and making outrageous claims and just taking stuff and running with it, right? And we saw this against Tyler Robinson in a whole myriad of ways. I mean, prime example was like the lip readers, body language experts, and so I get it that, whenever there seems to be some misinformation or a wrong analysis or, incorrect analysis on a piece of evidence or something that gets out, I get the impetus as a lawyer to want to jump out and correct that in the media. I know I spoke, and definitely Barron spoke about, back, and I'll say this too, we did get some light shed on the defense's previous private motions. I'll talk about that in a minute. But, Barron definitely spoke. I spoke a bit about, when we saw the ATF stuff and we kind of saw that the defense had filed this motion where it was private, it didn't make sense to us, because we were like, man, you'd want to get out there and build a counter narrative with that report being inconclusive, right? And, admittedly, I didn't think about it at the time, but maybe that would have been in contradiction of judge's order. I don't know that for sure, but I did get a little bit on top of feeling the prosecutor a little bit of like wanting to get out there and correct stuff in the media. I get that part of what we're about to talk about, but also felt a little bit of defense too today, as far as, in all honesty, order. I definitely need to go back and look at all that. But, defense brought up some parts of that order that make me think that, okay, maybe some of the stuff that, the defense didn't disclose or, sought to keep private, maybe that was really in furtherance of a rule or some other understanding. So, and again, we'll get into that. God bless everybody. I hope everybody's doing good. Hopefully Adam should be here pretty soon. Yeah, I pressed go. I'm sorry. I haven't gotten too far into it. I'm really just kind of introducing the issue here. Anyways, there were two issues, right? So I talked a little bit about the first one that I'm going to go into more depth about here. But the second one, which we'll touch on as well, was, to what extent is judge going to exclude, if any, right, media coverage at the preliminary hearing, okay? And what I'll say about that at kind of the higher level, and I think it probably makes sense to y'all, is that the defense is worried about, right? The defense is worried about the public having access and seeing, for instance, like Lance Twiggs' recorded statement. These other hearsay reports really are what the issue is, right? Because these hearsay reports, as they are not admissible at trial. And so the defense's worry there's obviously that they're going to, that we're going to see those pieces of evidence, not understanding, which is common, right? Not understanding that these are not admissible at trial and thinking that that's like really good type evidence that they can go run and get a conviction with. Okay. So that was really at the crux of it. Obviously at the far end, the defense wanted to completely exclude the media from the hearing. There was some concurrence with the prosecutor, who did agree that, like, there are some of the items of evidence that it would probably be better. And I think they got a feeling, a little taste of their medicine, as I was talking about on the first issue, with when the ATF report came out. They took issue with kind of how the media was reporting it. They claimed that the defense mischaracterized it, right? But again, just to say that, like, today was a little sweet in that we got to see the prosecutor reacting to them getting some bad takes in the press, okay, in regards to the ATF report and what it meant. I mean, I know just within our realm here on YouTube of creators, I heard several creators, going a little far with stating that, like, oh, this, it proves he's completely innocent. This proves that it wasn't the gun, right? When we know it was inconclusive. So it's not a 100% yes or no. But as Robinson's defense attorney explained today about exculpatory, they talked about the meaning of exculpatory. And I know that we've spoken about this a lot. I know other creators have spoken about it a lot and had asked questions about it. But exculpatory in the definition of that term, if I am correct in perceiving what the defense attorney said today, it really shifts depending on who the party is, but definitely in terms of a criminal defendant, because the state, the government, has the burden of proof. Evidence which otherwise might tend to show as guilt, like a positive identification on the ballistics test, well, when that comes back inconclusive, it's the absence of inculpatory evidence. It counts as the absence of inculpatory evidence, thereby making it, according to their definition, also exculpatory. And so I didn't want to go too far there, but just, that's what the prosecutor was having issues with, is that people were taking that ATF inconclusive report and really running pretty far with it. I mean, I'll say that admittedly, there were some people I think that gave an impression that and I don't think they intentionally did it. I don't think they intentionally did it, but, just gave the impression that had a little bit more force in the overall scheme of this case evidentiary wise than it did. But yeah, so the prosecutor's office, the DA, they felt that, and as we'll learn in a minute, went and made some pretty crazy statements, in my opinion, in response to that in the media. Okay, but back to that second issue, right? We have the defense wants to exclude all the cameras and stuff, and then the prosecutor, having felt that, hey, sometimes this stuff can go not our way and be interpreted in a way that we really don't like. Seem to be okay with like limiting like the public, right, from like maybe viewing those statements or watching the statements. So maybe and again, judge hasn't ruled on this yet, but obviously something much lesser than what the defense was proposing, just no access at all, right? So anyways, there is, I guess I say this, is that more likely than not, we're not going to be able to have access to see all the items of evidence that are introduced at the preliminary hearing. I 100% don't believe that judge is going to completely shut it down. I mean, just the way he was talking with defense counsel, he was saying like, hey, in regards to the media, the court has to like narrowly tailor its order or its response to the increased media exposure, which just means that like, we have to have the least amount of infringement on the public's right to access as possible. And the way his tone and measure when he was speaking with defense attorney made it seem to me like he thought completely closing it down was not something narrowly tailored, right? Not fully respecting everyone's rights, because it would technically leave all of us out in the dark and be infringing upon our rights. So I suspect that judge will come up. We will be able to have, I believe we'll have access live stream to the preliminary hearing. I think there might be a few times where it might shut down for a bit, maybe while they read a statement or play the video of Lance Twiggs or whatever that is. Okay. And so just be prepared for that. Okay. And I guess in regards to that issue, I will speak a little bit further on it. And obviously Adam will be here. I'm sure he'll bring up some questions too, if y'all have any, but I'd really like to jump over y'all to the first issue again. As a matter of fact, I brought here, and I'm not going to bury y'all in this one. Okay. But I have a copy of the pleading. And so I just want to go through a few sections with y'all. Give me just a second. Let's see. Pull this up. Okay. Should be there. Let's see here. I don't, for some reason, I can't see my PDFs in here. Let's see. I'll do this. I'll give it a minute. I'll wait for Adam to show up. But I'll just talk about the different issues. And I have the pleading right here in front of me, so I can quote from some of it. But yeah. So again, the first part of this hearing today was on basically what the defense is asking for is an evidentiary hearing about, again, the claim that the prosecutor, after they filed for an extension of the preliminary hearing, the prosecutor, because of the way that the defense disclosed and discussed that ATF report favorably, as they should have without stretching the truth, which I think that they absolutely did, But according to the prosecutor, how they characterize it, how the media later ran with it, they went to the media and started making statements, obviously in opposition. And so the defense now claims that those were extrajudicial statements, right? Not statements made in a pleading, right? That's a judicial statement, theoretically, technically, right? But extrajudicial to the news, Fox and Friends, these people, extrajudicial statement. And we'll talk about in a minute what that statement was, that offends both the judge's order and the model rule of professional responsibility. Therefore, they are in civil contempt of court. I know. I'm not sure where the civil came. I know they explain it here, but yeah, it's civil, not criminal, because it's the DA, I guess. I don't know. And again, not trying to rouse everybody up saying that. Anyways, yeah, so because of that, they're asking the judge to hold the prosecutor in contempt of court, which could, bring a whole host of different potential remedies, right? Everything from like censuring the lawyer who did it, maybe taking them off the case, possible jury instructions. There's a whole list of different potential remedies that judge can employ here. And again, he did not make an order today. He's taking this under advisement. And moreover, if he indulges in the direction of, I think they're in contempt of court, like I said, there's going to be an evidentiary hearing, I do believe. That's what the defense was asking for today. On top of that, just so y'all know, after the defense witnessed these very prejudicial, extrajudicial, and potentially violative of the court's order and model rules statements, okay, they sent a discovery request directly to the prosecutor, asking a supplemental discovery request, asking, all right, we'll see you in just a second, Adam. Adam's about to be here. But anyways, yeah, so they sent out, where was it? Sorry, y'all. They sent a discovery request, a supplemental discovery request to the DA's office, requesting that they provide them with any documents, communications, or other information that would show or be evidence of any internal conversations and discussions that they might have had about this media tour, blitz, whatever you want to call it. And the purpose there, as we'll learn in a minute under the rule, is really to gauge what level of culpability did they have? Meaning, like, were they consciously aware this violates the rule, yet did it anyways? Or were they kind of unsure about it violated the rule, did it anyways? Or did they not even look at the rule? So obviously, as far as being in contempt, their internal mind state isn't relevant, okay? But when it comes to judge deciding what do we do to remedy, okay, to provide a remedy to Tyler Robinson, which in this case, a remedy would be trying to put him back on equal footing for a fair trial where he was before, right? Because they prejudiced him. So the remedy would need to be with the spirit or the intent of trying to bring him back to where his rights put him for a fair and impartial trial, okay? But anyways, they sent a discovery request to the DA's office seeking those materials. The DA has either not responded, or I think actually they've overtly told them they're not going to respond. So that was at issue too. So seeking a motion or seeking an order to compel them. So basically, it's that if judge decides to go to a evidentiary hearing on this, more likely than not, he will issue an order to compel the DA's office to release all that information and discovery, probably both to the court and to the defense attorneys, in order to fully assess. And he's under advisement now, but then to fully assess whether they're in contempt of court, and if so, what would the appropriate remedy be? Okay. And so I hope that provides kind of the higher level view there. But I know y'all are probably most interested in saying, well, hey, Greg, what statements did they make? What statements did the prosecution make? Let me read a little. For just 1 second. Again, Adam should be here any minute. But anyways, let me read real quick from the relevant facts. It says, on September 22nd, 2025, the court issued an order governing the conduct of the lawyers participating in this criminal case. We all know about that. The policy directs that the lawyers who have participated, who are not participating, who will yet participate in the investigation or litigation in this case, in any way, must strictly comply with the provisions of Utah Rule of Professional Conduct 3.6. Like I told y'all earlier, it's judge's order, but adopted, obviously, a lot of the professional other rules, case law, stuff like that. So they point out that, so judge, here in your order, you're citing that these, pretrial publicity, part of it applies to the lawyers in this case, in Tyler Robinson's case, right? Okay. So they go on, and here's the language from the rule. An extrajudicial statement that the lawyer knows. Okay. So a lawyer is prohibited from making an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication. And that means extrajudicial, right? And will have a substantial likelihood of materially prejudicing an adjudicate proceeding in the matter, right? So it's reasonably knows. I'm trying to think the best way this to get it to y'all surface level. Yeah. So anyways, any extrajudicial statement that the lawyer knows, again, so outside the courtroom, outside of a pleading, outside of a deposition, all these things, right? Extrajudicial statement that they know or reasonably should know are going to be carried to the public by means of, public communication, the media, right? And will have a substantial likelihood of materially prejudicing the proceeding. Okay. So that's the general rule. Now, I want to read so just so y'all know, legal rules a lot of times, maybe y'all are aware, maybe you're not, have what are called comments, okay? And so in the comments are usually a lot of good material, and it's a variation of things. A lot of times they'll have examples, they'll clarify things, give you other references to other materials that were involved in these types of things, right? So this rule has a comment that describes certain specific types, okay, of extrajudicial statements, particularly in a criminal matter, that normally are prejudicial to some degree. Okay, so let me pull those out for you. So because they're important, one, because obviously they fit squarely within what the or at least one of them fits squarely within what the prosecutor did here, but also two, because there's been a lot of discussion and commentary about these certain types of statements, just so that way you can cue yourself in the future. But here we go. One, so discussing the performance or results of any examination or test. Okay, so talking about expert stuff, right? Tests or examination primarily, right? It could be part of an investigation theoretically, but anyways, or the identity or nature of physical evidence expected to be presented, right? Which raises a lot of questions for me. Maybe we'll get there down the road. I hope Adam shows up in a minute. But two, any opinion as to the guilt or innocence of a defendant or suspect in a criminal case or proceeding that could result in incarceration. Man, have we heard any of those by any officers of the court, or any of the lawyers in the case? And so one thing I would like to ask maybe the state bar or the rules committee is that, because I'm almost sure, and we can look back, but I think that the attorney general or even maybe the governor have made statements that are violative of this rule. And even though they're not an attorney in the case, at least the AG for sure is an attorney and otherwise does represent the state of Utah. I mean, I'm just wondering if this applies to them too. I'll look into that and get back with y'all. And then the last one is the fact that a defendant has been charged with a crime, unless there is included therein a statement explaining that the charge is merely an accusation and that the defendant is presumed innocent until and unless proven guilty. Man, yeah. So I hope y'all understand. Now, those are just three. Again, the comment just adds these categories saying like, hey, by way of example, and by the way, these specific categories tend to prejudice people in defendants, particularly in a criminal matter. Okay. So I just wanted to bring that out for y'all. Now here, and so back to what I was saying earlier about, you remember when I was saying that the defense was seeking discovery of internal communications, right? That the Utah County DA's office internally knew about this standard, talked about this standard, yet decided any ways to move forward. Okay. Now today in the hearing, and Adam's here, by the way. You ready, Adam? I'll wait for a second. I don't see his camera yet. But anyways, today the DA's office in open court basically admitted that they were very well aware of what the standard was. And they, I think in a sense, admitted also that, yes, there were internal discussions about this before we went and did it. And let me say this, the existence of internal discussions isn't a negative necessarily on the contempt part of it, right? Like maybe it shows that they were very concerned about potentially violating the rule, but maybe at the end of it, they just made a bad decision, but they did bring up and legitimately consider the relevant, stuff. It could go both ways. So, but they did admit today they were aware of the standard, that they had some discussions. This was their plan, et cetera, et cetera. So I'll talk in a minute about what their counter argument to all this was, but I will say this, the gist of it was that, we have a duty to our client, the state, to be zealous and in zealous advocacy, if there's media out there misconstruing something, in opposition to our client's interest, we have a duty. They argued essentially, bluntly, I don't want to say essentially, bluntly, that they had a duty to make the statements that we're going to discuss in just a second. Okay. And again, I'm not going to sit here and say, oh, they're crazy for saying that. To be just 100 with y'all, I haven't read their memo in opposition to this motion. But that was the main gist of, why they went out and did this legally, why they felt that they were correct in going out and making the statements that we will now go ahead and get into. Let's see. Oh, and one footnote here. One footnote, just so you know. The defense had a feeling that, in fact, the DA's office was for sure, acutely aware. I mean, obviously, that's an order governing their case. They're at least generally aware of this rule, what it requires, but acutely aware because I guess they found out, or maybe in discovery, they found a letter sent. And I want to tell y'all this because now when you think back about all the statements by all these, federal and state agents and people have been made. But anyways, the Utah County DA's office sent a letter to their law enforcement, both federal and state, and other investigators and attorneys working in and around this matter. And it says in these letters to law enforcement and other agencies, and this was early on, by the way. I think this was shortly after Tyler Robinson was actually arrested or charged. So this was a long time ago. But they sent out this letter emphasizing in caps, do not make comments on his, talking about Tyler Robinson's, character or your belief of his guilt. And it said these letters also list the categories of prohibited statements under 3.6, comment 5, and include as a consideration Mr. Robinson's right to a fair trial. So they actually sent out a letter. I didn't read that earlier, but those three categories of statements I just described to you, their letter actually included that language in telling other officers and other investigators and attorneys and people working around the case not to make these kinds of statements. Okay. So anyways, let's go ahead and get into exactly what the statements were. And again, I don't think Adam bailed on us. He's still here in the waiting room, but I just don't see his. Let me check my phone, y'all. I'm sorry. I'm sitting here yapping away. He might have texted me. Let's see. Okay. All right. Well, I just sent him a text. We'll see. But anyways, let's talk about the statements. So like I told you, the statements were made essentially, and it wasn't just, and I don't say there's one precise precipitating moment where the DA's yeah, I've heard that. But between the way I took it anyways, right? My perception of the hearing today, they were explaining the way that the defense presented and characterized the ATF report and the language therein in this March 27th motion to continue the preliminary hearing, that, and then the way that the media picked up on that and ran with it. And again, like I told you, in all fairness to the DA's office, there was some mischaracterization a little bit. I don't think it was intentional on anybody's part, to be honest. I don't think anybody was intentionally misconstruing. It's one of those things that really it takes a lawyer to really understand. I mean, I'm not saying it only takes a lawyer, but most normal people don't generally understand the effect that inconclusive report necessarily had on what do I want to say? Well, in the prosecutors, like I said earlier, had an issue. He couldn't see how the ATF report being inconclusive was exculpatory in any way. Obviously, and I'll explain it again in a bit, but the defense lawyer got up there and corrected that and gave us a much more refined definition of exculpatory. I loved it. And so, because of that, obviously the DA felt that, this was being incorrectly labeled as exculpatory. People were taking that and saying, oh, now there's absolutely no evidence or case against Tyler Robinson. The gun just absolutely does not match. Okay. So yeah, there was some taking a little bit far and mischaracterizing it. I don't think it was intentional, but anyways, hey, y'all got into the feelings in the head of, of the DA's office apparently. Right. And, that's what, got their response going. They did say, so I want to say this, I'll just read this. Mr. Robinson filed a motion to vacate or continue the preliminary hearing. In detailing why good cause exists to continue or vacate the hearing, Mr. Robinson referenced forensic testing by the ATF that he may seek to introduce at the preliminary hearing. The motion was filed as a public document. Okay. Mr. Robinson did not request that the motion continue to be filed privately in light of this court's rulings, right, on the last motion to classify as private. Because of that, they chose not to, they go ahead and put it out there. So that's where they started by the ATF. Therein, the court denied Mr. Robinson's earlier motion to classify as a private. Yeah, so they had previously ruled, hey, no reason to do the private motion in those regards. But the defense does say the ATF reported issue in Mr. Robinson's January 9th motion is the same report cited in his recent motion to continue, right? So and I'll talk in a bit why they filed that as private, right? There were reasons I wasn't aware of at the time that they kind of enlightened us on today. I'll speak in a minute. But basically they're saying because you said not to have that as private, we didn't file the ATF report or talk about it, privately here. And so it says the defense earlier and continued but opposed and rejected concern with filing this inconclusive report publicly was that doing so would be in effect an improper in-run around Rule 3.6. So again, when we went back to 3 points, and so that really goes to what I was saying just a second ago. Their reasoning, okay, for classifying the January 9th motion as private is because they felt that it was contrary to the Rule 3.6, which I read to y'all earlier, generally says that evidence related to the performance or result of any examination or test or the identity or nature of any physical evidence expected to be presented, generally extrajudicial statements made disclosing or commenting on those types of evidence generally tend to go the prejudicial route in some way. Okay. So that's why at least one of the main reasons that I took from today's hearing that the defense had filed that motion as private originally. Okay. But anyways, they didn't this time. The media picked up on it. They took the word exculpatory apparently and started to run with it. And the DA was like, hey, okay. So what did the DA say in response? Okay. So I'll read through a few of these and let me just see real quick if I can pull this up. Let's see. Hold on. Let's see. Okay. There we go. Okay. Now I got it. Okay. There we go. I just wanted to show you all these statements while we go through them. Obviously, I'm going to put my screen over here. Let's see. We are on page 6. All right. So here we go. On March 31st, online news entity TMZ published an article entitled Charlie Kirk Murder Suspect Prosecutor Slams His Claims Bullet Doesn't Match. All right. So now you can kind of see how, admittedly the media, can take it a little far. Anyways, the article states, Attorney Christopher Ballard tells us, again, that's the DA, or works for the DA, generally when a bullet fragment analysis comes back as inconclusive, that means the fragment did not contain enough detail for the examiner to say one way or the other. There's just not there's not enough there to determine whether the bullet was fired by a particular firearm, meaning the fragment is too small to really do any kind of examination. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing. and then we will present all of that evidence at the trial. Okay. So again, there's a number of things that the defense is stating that, this is violative of the rule. Now, I will say, here where they say generally when a bullet fragment analysis comes back, that means the fragment not contained. I agree with that statement for sure. There's not enough there to determine whether the bullet was fired by a particular firearm. That's right. And also in defense, I guess in defense of the DA here, right? They did narrow it down to a 30 caliber something, right? Which we've learned is a lot of different potential firearms, right? So they definitely haven't narrowed it down to a particular firearm. So, that is correct. Okay. That's technically correct what he's saying here. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing. So this is the one that obviously starts to potentially run afoul of that Rule 3.6. And if y'all want to, we can kind of go back here and look, So any opinion as to the guilt or innocence of a defendant or suspect in a criminal case or proceeding that could result in incarceration. So obviously that is an opinion of sorts couched in a declaration essentially. But again, rubbing up on this here, obviously making an extrajudicial statement to the media about the examination or test. Also, again, this doesn't mean carte blanche that this violates the rule, but again, these types of statements with this kind of subject matter, according to the rule, are more likely than not going to have a material and prejudicial effect on a proceeding. Okay. And I don't think that one's applicable to that. So again, just kind of showing y'all here where the defense is going, why some of these statements are potentially against the rules of professional conduct, and or the court's order here. Okay. I hope this is informative to y'all. And to be quite honest, again, I've never been personally involved in a murder or a capital, obviously, trial. So I'm learning a lot here too. So this was good for me to learn today. So I hope y'all are picking up on it a little bit too. It goes, the article further quotes Mr. Ballard. He told us, quote unquote, he can't speak about specific evidence, but the evidence that we detailed in the charging document is a general summary of the evidence that shows Tyler Robinson committed this crime. Again, even though I'm assuming the defense is considering this to be somewhat of an opinion on the guilt or innocence. I'm assuming. But it goes on. Finally, TMZ states, Ballard added, he is presumed innocent. So, hey, he did include this statement. He is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence. So, hey, maybe in regards to the fact that this expresses some type of opinion on the, guilt of Tyler Robinson. Let me go back up here and look. Does adding that statement, where's that Rule 3.6? Let's see. 3.6 says that purpose of making an extrajudicial statement the lawyer knows or reasonably should know, have substantial likelihood. I'm looking for the part earlier where, okay, here we go. Yeah. The fact that a defendant has been charged with a crime unless there's included there in a statement explaining that the charge is merely an accusation. Okay, so never mind. Expressing an opinion as to guilt or innocence, the way I'm taking it, isn't mitigated by including this statement explaining that the charge is merely an accusation. The way I take it is only if the statement's, hey, we charged him with a crime, so here, what we do see, I think what we do absolutely see is that Ballard in them, and this again, just speculation here, this would probably come up in the discussions, internal discussions, if it's on paper, that they say, hey, if we make these types of statements, that he's been charged with a crime, yada, 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 that we will follow it up with this, he is presumed innocent, XYZ. So I think what we're seeing here are Ballard and them attempting to comply with the rules. So, and as far as what they admitted today in court, it seems like even if the judge does find that they were in contempt, I don't think it's going to be just an extremely severe repercussions for them. take that as you will, whether you like that or not, right? I'm not going to express on what I think should happen here because I really need to research a little bit more about the potential remedies and what's normally done. But just the way, hold on just a second, quick. I think he's having some technical difficulties. But, the way I'm taking it here, y'all, is that they did do some proactive trying to comply with the rules. And so I think when it all comes out in the wash, if judge takes this further on the contempt, it probably won't be a severe penalty for them. Okay. I just wanted, and again, that's just my opinion, my impression based upon what I'm seeing here. It looks like they did try to actually, do something to comply with the rule. Just 1 second. Okay. All right. Adam should be on soon. He had to restart his computer. Anyways, let's just keep going a little bit. Let's see, because there's another statement here. And I actually made an X post about this one here earlier because it raises some other questions. Okay. So let's go ahead. As a matter of fact, this is what I really wanted to bring to y'all tonight. Okay. Y'all ready? Also on March 31st, 2026, USA Today reported communications with Christopher Ballard. Okay. Writing. When asked about the defense's characterization of the ATF report, Chris Ballard, a spokesperson for the Utah County's DA's office, told USA Today ethical rules prohibit him from speaking publicly about forensic testing and test results. So again, even outside of potential communications, again, we see that they are aware and are at least doing something seemingly to try and comply with the rules. But let's see if he keeps this up. Okay. But I can say generally that when the results of a bullet fragment analysis come back as inconclusive, that means only that the fragment did not contain enough detail for the examiner to determine whether the characteristics on the fragment were consistent with having been fired by a particular firearm. So now he's speaking generally, okay, so we'll look at that. But hold on just 1 second because our good buddy, y'all's best buddy, buddy's best buddy, Adam is here. Welcome, Adam Thomas, to the podcast. We're very grateful to have you. Maybe his volume is not working now. Adam, you want to check your mic real quick? A little technical difficulties.
Hey, what about that?
Nope. Let's see. Maybe my volume's low. No? Speak again. Can y'all hear him?
What's up?
Can you turn the volume? I'm having a hard time with the volume. Are y'all having out there trouble with the volume a little bit? I'll bring my speakers up here. That way I can make sure I get the sound. Anyways, while he's figuring that out, I'll keep going. Back to the statement here real quick. I'll put it back up. So as we see, it says, but I can generally say, okay, so we read that. Now, here's the last little part here that got me, y'all. Here, I'll put that up here. Here's the little part that got me, and I'll talk about this in just a second. It says, Ballard can confirm the FBI and ATF are adding information to the initial reports, which prosecutors expect will include data supporting the initial conclusions. As soon as the state receives those supplemental reports, we will provide them to the defense. Yeah, so I've got some questions about that. And in all honesty, y'all, now that I'm looking at it, I see that actually okay, never mind. This was actually written in the article. So he did talk to the press. This is the press saying, Ballard confirmed the FBI and ATF are adding information to the initial reports, which prosecutors expect will include data supporting the initial conclusions. Okay. So let's talk about that for a second, and we'll let Adam continue getting his technical stuff work out. One, there has been, to the best of my knowledge, concern expressed within the community. Because remember, initially, whenever this report came out, okay, and through that, I forget, it was one of the hearings, I then learned that there was a dispute behind the scenes between the prosecutor and the defendant, right? because apparently that bullet fragment is very small, and the FBI was one, or the ATF, or both of them were wanting to do destructive testing. Do y'all remember that? And I think that is still a thing, right? I think there's still potentially going back and forth about that. But anyways, whenever they announced that, we all had concerns. I mean, I'll admit, again, this is just my opinion, my perspective. I had concerns based upon the way, particularly the FBI had conducted themselves, or, you know, particularly one FBI agent, right, across this whole spectrum here. I had concerns that, you know, if the defense experts didn't have a chance to take a look at this bullet fragment and do an analysis of their own of some type, it didn't feel good to me. Okay. It didn't feel good to me. And then we've been hearing these rumblings, and they've been talking about it in these hearings as well as, you know, also out here, you know, that the FBI ATF are going to be generating another report. Okay. That they're working on, and whether that includes further testing, destructive testing. So here it seems, now, I haven't heard that they've done the destructive testing. So what I'm about to say is really assuming that there is some type of bullet fragment still left, and that there has been further testing on it. So I'm wondering, it just makes me wonder, going back to what was said here, and maybe there's a good, simple, basic explanation for this. Maybe y'all can enlighten me on it, but I'm having just a little bit of trouble with, and let me make sure this. Okay. Do y'all see the whole thing there? Yeah, y'all do. Okay. Sorry. Anyways, I'm having trouble with, are adding information to the initial reports. I mean, I'm just wondering, and then further that I think it's fair to assume here that the Ballard will include data supporting the initial conclusion. So it's like, one, the information. What information? Like, if the FBI and ATF are doing forensic scientific testing, obviously that is on physical items of evidence. Okay. And so I'm not sure where some extraneous information is going to come in and change the results of a scientific test and report. Does that make sense to y'all? And moreover, even if we are talking about more testing, right, and just putting aside the bullet fragment that's there, you know, or is there other forensic evidence that they're testing? And the reason why that's concerning to me, if so, is that, you know, they've had, since this occurred, to collect and get all that. You know, they paved over the crime scene. Or did they magically appear some new bullet fragments? Did they magically appear new items that they claim have DNA evidence from the crime scene? You see what I'm saying? And again, maybe there's some just real common sense, straightforward explanation to how this doesn't sound a little bit fishy to me. Again, that's just my opinion, perspective. But this is just how I'm reading into it, y'all. Let me know if you agree or not. But I'm sitting there thinking, so these presumably expert investigators, they're going to add information to a scientific expert test report, which will include some kind of new data supporting the initial conclusions. Well, whose conclusions? What conclusions? You know, I mean, and maybe I'm completely left field here, right? Maybe I'm completely left field. But I'm sitting here wondering what conclusions. There goes Adam. Adam, you ready? You got the. Let's see if he's got the mic here.
Can you hear me?
Yeah, there you go, brother. Yeah.
Oh my God, I'm telling you, but
man.
After all this, I am, good God, I was about this close to throwing this laptop and going to bed. Oh.
Yeah, well, we're glad to have you, man. God bless.
Well, it was working fine earlier. I knew it was working fine earlier, and then when I come into the studio and I had to run back downstairs, come back up here, and there was some kind of freaking ad playing, and I could not get it to close for nothing. I had to end up restarting my computer. Somehow or another, I had to go back into the computer settings. It got muted in there somehow. My microphone did, so I had no clue. Good.
Yeah, I had some difficulties the other day myself. You know, these computers, man, you know, they're reliable, but sometimes in the clutch, they they can let you down a little bit.
I don't know what happened there. Anyway, what's up, everybody in the chat? I see Crystal and Brett and Mermaid.
Yeah, we've got a good group here tonight. A lot of our regulars plus a lot more. I think we're about almost 50 watching. Hey, that's huge for us. Thank y'all, everybody, for love and support.
I hope somebody's watching on my channel.
Yeah. If you get the chance or bandwidth, please go subscribe to Adam Thomas Podcast. If you got a little bit left in the tank, the Entheogenic Esquire, be very much appreciated. All the likes, loves, comments, support.
Definitely.
Very blessed to be here today. I had taken a little bit of break from this case and stuff, and so today was like my first day. It was like watching the hearing, taking notes, going and looking at pleadings. So I'm loving it, getting back in the groove, and very happy and blessed to be here with Adam sharing. Did you get to hear some of what I kind of covered already, Adam?
Bits and pieces.
Okay. Well, I was talking about the defense wants to hold the DA in contempt of court for violating the initial order, making extrajudicial statements.
Yep.
I was just going through some of them. I tell you what, let's read the last extrajudicial statement that I just brought up because I want to get your opinion on it. Okay.
I was able to listen to some of it. I didn't get to listen to all of it today, the hearing. But okay. I did catch some of it. So, hey, Kelly, what's up?
Yeah, it's this one right here where the defense attorney's talking, or the prosecutor's talking to USA Today, okay? And he's talking about the ATF report, right? And he says here, just because it came back inconclusive doesn't mean that it, means, for sure it wasn't Tyler, but it just can't, he correctly states that. And he does. Or this is what USA Today reports, right? Maybe there was a loss in translation or garbled. Anyway, it says, Ballard, the DA, confirmed the FBI and ATF are adding information to the initial reports, which prosecutors expect will include data supporting the initial conclusions. As soon as the state receives those reports, we will provide them defense. I'm having trouble with this adding additional information to an expert report that's like a scientific test, of like a physical piece of evidence, that doesn't sound right to me. It seems like if you're going to change that expert report, it needs to be because of changes in the testing results, right?
Yeah, you would think so.
Information or data,
now, is that what is that what they were talking about earlier? That the ATF and FBI both said that they were making changes to? Is that what you were talking about? Or
yeah, exactly. Yeah. That's what I was talking about. Yeah, and I'll say this normally, ladies and gentlemen, an expert can surely change their expert report later if new or additional evidence, right? And I guess you could say information, evidence or information, but again, in the context of these experts' reports, well, all I can say is this: is
that not the foundational thing, though? Is that not like all their methods and how everything was collected and processed? Is that not what they're changing?
So now I'm saying, look, maybe if there was some authority that came out that basically said that even though, what you're looking at used to not be a match, now this new authority is saying that, no, that does constitute a match. Maybe I could see that. But again, more times than not, it's going to be, did the testing change? Did you test something additional, or maybe you did another different test, right? But and maybe data could confirm that. But it's fishy to me because it just seems like there's this one item of ballistic evidence, right? The fragment that's been tested by them. I don't think the defense has gotten it yet. I'm almost sure of that based upon today's hearing. And so I'm just wondering, did they test other evidence? Are they testing other evidence? How are they changing this report? I
don't know. It kind of seems like it seems like there's somebody on the inside that's trying to just completely discredit.
It's or just making it up as they go. Literally making it up as they go and just admitting it in USA Today. I'm not saying that's what happened.
The feds are like, hey, we ain't turned it over to the state or the defense, so we can do what we want to with it until we turn it over to the state.
And so many, I kind of chuckled when I read this because I know a lot of people in our viewership definitely have had questions like, man, what are they going to do with that bullet fragment? I hope they don't destroy it. If they destroy the bullet fragment and not let them test, that'll be a grave injustice. So it's this right here, like basically they're just going to do it on their own and make it fit is a lot of people's
That's
concern,
what it kind of
right?
seems like it boils down to, right?
And it's like, not only that, they're like, the prosecutor expects the data will support the initial conclusions. Well,
of course it will.
Well, yeah,
Of course.
exactly. It's like, it's like, dude, experts don't work from conclusion backwards. You know what I mean? Like they work unidirectional, and then it's like
usually
whose
anyway.
conclusions? What conclusions? Like,
Yep.
yeah, I was kind of taken aback at that. I was like, man, it just seems like they're just openly stating, like, yeah, we're just going to add some information and data into that report. Jumble it around.
Yeah, I mean,
it's going to be a for sure, match.
So the original report said we can't confirm or deny.
That's right.
Basically.
That's right.
So they're like, okay, well, we need something more definitive. So we're gonna work on this until it's confirm only.
That to be, yeah, and I guess that's why I decided to make a big deal. I say a big deal, make a deal. I made an X post about it. It just when I read it, it just hit me like, dude, are they just telling us they're just gonna make this work?
Pretty much.
Like, wow.
Pretty much. That's exactly
Wow.
what it seems like to me.
And
I mean, it's been that way from the get-go.
Yeah. I mean, and again, you feel that way. I know a lot of people who are in our chat today have felt that way.
Well, just the fact that they haven't gotten that underlying data yet, to me, just blows my mind.
No doubt. And here's one other thing I wanted to point out. It says here, there's another Fox and Friends. Here, I'll just bring it up real quick. This Fox and Friends thing, because it said something too it's about the shell casings. And so here it says, the description of this video where Christopher Ballard, Utah County prosecutor, and Bernard Zapor, retired ATF agent, debunked these claims, stating bullet fragments were too damaged for conclusive analysis, but shell casings matched. I don't remember hearing that or seeing any report that said definitively the shell casings matched.
Who cares? They're not picking a shell casing out of his body. The piece that they find in his body is what has to be definitively matched.
That's a very
good firearm.
That's a very good point. That's where that shell casing could have been shot
anywhere,
in Africa, for all we know,
anytime.
On an elephant hunt. Yeah, no, you're right about that. That's a very good point. Yeah, so I also saw that too. But no,
that sounds good on the news. That sounds good on the news, but at the end of the day, I would think if they had a decent jury, I mean, it doesn't really mean anything.
Yeah, and they did, today during the hearing, the prosecutor, I told y'all, had a big issue with the defense using the word exculpatory. And again, the defense did a really good, in my opinion, explanation of what exculpatory means in terms of a criminal defendant. But it's like, anytime you have because there's a presumption of innocence, the burden is on the state. Anytime you have a lack or missing piece of evidence where otherwise there would be a pretty damning piece of evidence there, like a bullet fragment that matched, that is considered exculpatory because it's tending to show his innocence because the state doesn't have that evidence that they might otherwise have. Right.
No, but you can't use that word though.
They got upset. And again, that's why, that was their reasoning. Well, a lot of it, the way that it was characterized, they said in court, there's just no way, Judge, that I could, calculate this up to in any way be exculpatory. There's no way you can work it out to be exculpatory.
I'll leave that up to the defense. If they think they can, then, I mean, look, when they talk about any of the other, evidence, like when the prosecution side discusses it, I mean, everybody knows that when they're talking about evidence, I mean, we all know what kind of evidence they're speaking of. So, I mean, I don't understand what the big deal is about somebody claiming that something might be exculpatory. If they think that they can make it, or argue it to be exculpatory, then.
Well, and the thing is too, it's like,
like they're not worried about bias against him.
No, not at all. No, not at all. And as a matter of fact, they've done pretty good at perpetrating it, in my opinion. Right.
Yeah.
And moreover, yes, and here's another thing is, okay, I guess I understand a little bit why they kind of got up in arms about it, especially when the media ran with it. But hey, it's a taste of their own medicine.
Oh, yeah.
And two, it's like it's one piece of evidence out of this whole 6-7 page, affidavit that y'all filed. There seems to be reference quite a bit of evidence in there. Why is this one bit of evidence being labeled by the defense, I feel appropriately exculpatory? I mean, that damn meaningful to like go out and like, have meetings about whether you're going to violate the rule or not, potentially put your, I say licensure, not like
because their whole case is going to come down to this.
And I've always said too, I think
they know that it's a lose-lose.
Yeah. I think the messages, the Discord and the text messages, I also think are really like crux, like they're very dependent on those things.
Yeah, but I feel like, and I could be wrong, I'm not on the inside, from the outside looking in though, I really feel like those Discord messages are going to end up being a bust also.
I think, absolutely too. And, I guess, in regards to the physical evidence found outside, that's linking him to the actual crime scene physically, which, in your opinion, obviously that's a pretty important part of their, being able to prove his guilt beyond a reasonable doubt.
Yep. Look, they were already, prepping everybody, kind of warming people up, when they were talking in that last hearing, when they were talking about all this video footage that they've got. They made sure and they didn't say that, you can plainly see him and positively ID him, as being Tyler Robinson and all these. It always talked about how much he avoided the cameras and tried to keep his face, and disguises. And like they used a lot of that type of language, which to me indicates that this footage is not going to be that good.
Talking what in regards to
they were talking about the footage that they had showing him before he made it onto campus, and then once he made it onto campus,
okay, so like the Ring doorbell cameras and stuff like that.
Well, not just that, but even the on-campus stuff, talking about how it shows him going up the stairs, getting to the sniper's nest, but it kept talking about how he was trying to evade and disguise, and it used so much of that language that I've got a feeling that this ain't gonna be crystal clear footage showing,
you just raised a kind of a interesting point too, is the tension there between the prosecutor claiming that he did all this to disguise himself, yet claiming at the same time that this video is like, that's Tyler Robinson, clearly,
Yep.
Yeah, there's a
want to bet it'll look more like Lance Twiggs than Tyler Robinson.
Yeah, there's an intellectual tension there, right?
I think there is. To me, it just seemed like they were prepping everybody to look at that video and be like, yeah, I guess.
And I'll say this, I think the more people look at those videos, the more they're convinced that it's not Tyler Robinson.
I know that's the way it has been for me.
Yeah, it has for me too. It's funny how the media works, because it's like, when I first saw it, I was like, that might, that's definitely not wholly inconsistent, but it's like, the more they've like beat it down my throat, beat my head with it, like the more I'm like, that doesn't really look like Tyler Robinson.
They're trying to convince me way too hard. And look, the parents, it said that I don't remember exactly how it said, like basically when they saw the news footage or the footage that the FBI, they had put out, that they had said that it resembled Tyler, I believe was the terminology, or something to that effect. Mm-hmm. Not that they positively ID'd Tyler, without a doubt. Yeah. Same thing as this quote unquote confession that the parents got. No, they said that when confronted, Tyler indicated to them that, he had done it. Indicated, that doesn't sound like a confession. Hey, I killed Charlie Kirk. I took Grandpappy's 30-06 down to the, college and shot Charlie. That's a far cry from indicated that it was him.
Yeah, absolutely. Yeah, and again, and also as we've pointed out, the tension of, I don't think the kind of rifle they're claiming is his grandpa's looks much like the one that they put on TV, claiming that's the one that dad or grandpa saw. That so yeah, there's those inconsistencies too. It's just everything that we've seen, and as far as I'm concerned, for what it's worth, I just don't see anything solid enough to get a conviction right now.
I don't. Yeah. And I don't know if you remember me telling you this or not, but of course, at the beginning, after that article came out with the pictures of the 30-06, once that came out, it wasn't long. People started digging into it a lot, and then all of a sudden it was like it just got scrubbed. And you can't find it anywhere.
That's right. That has
the only picture you can find of that thing is the. Excuse me. The only picture you can find of that gun online. There's nothing prior to the news. The article that came out with the pictures, and so. But I was doing some digging because there were lots of people that claimed that they had looked into it early on and that they had found other photos from other places, of the same gun. I don't know. I was digging into it. The best I could get, though, was that either Grok or ChatGPT, one, though, said that it was most likely not a police crime scene photo. And that was based on the light and the angles and the quality, and that at, real close examination that it appeared to be a screenshot of a video based on, really, really close, like on little slight blurs and things that you can't just pick up with your eye. So, yeah. Yeah,
man. Rick asked, I'm interested if the prosecution broke the gag order. So that's a very good question, Rick. And like I said, judge didn't rule on that issue today. Obviously, the defense's position is that they did. And again, those several statements that I read that the prosecutor put out in the media, those are kind of the crux of the offending statements according to the defense. So obviously, we don't know yet. I mean, I'll just say my feeling based upon the rules I read, hearing the arguments today, and I do think they did. And let me say this too. Judge seemed pretty receptive to the defense's argument along these lines, to be quite honest with you. The judge did. Now, again, I'm not going to say that as any indication how he's going to rule, but it did seem that he was buying into it pretty good while the defense was arguing, and he did give the prosecutor a little bit of a hard time on several points. So it'll be interesting, but I guess to the main answer to your question is that we just don't know for sure at this time.
That poor judge has got a fine line he's got to walk with.
He does. He really does. And here it's like the reason why I do think that he's really maybe going down that road is because, on appeal in a capital case, that might be a good grounds for appeal if the prosecutor did something like that. And it was not, again, there was no remedy. Like I told y'all, if judge is going to give a remedy, the target is to try to put Tyler back on equal footing with his right to a fair trial, right?
Yeah.
There's different ways they can go about that, like enlarging the veneer, meaning the jury pool, allowing for extra time at work. There's a lot of different things, censuring the attorney, right? So I think to the extent he is biting, it is obviously for appellate considerations, right? Because if he's going to do something, he wants to make sure on appeal it looks the best possible to hold up.
Because everybody knows it's going to be appealed if it ends up being.
Oh, absolutely. Pretty much.
It's a given on a case like this. You know what I mean? It's a given on a capital case like this. It's going to go as far as it can go in the court system. Yeah. So, they just want to have all their T's crossed and I's dotted for when that time comes, because it's coming. Unless he gets acquitted. If he gets acquitted, we won't have to worry about an appeal. But
so let me say this real quick. So I want to. So the defense in this motion talks about this case called Levitt. Now the defense points something out, and I think this might give an eye towards what they want as a potential remedy. But it says There could be potentially an order barring the state from seeking the death penalty. Is not without the gambit of potential remedies that judge could, make an order here. Okay. I just wanted to say that because it's in the brief here, although the defense doesn't come out and say that, hey, we want an order preventing the state from, pursuing the death penalty. They talk about this case and they bring that up that, hey, even though the judge didn't prevent the state from pursuing the death penalty in this case, it was discussed and judge did not shoot it down. Like that was outside of the purview of possibility. So I just wanted to throw that out there too for everybody. So that might be something that we see. I don't know. That would be interesting.
Yeah. And if that happens, which I've been hoping and praying every single day that it doesn't get appealed. But if something like that happened, then that would at least, I think, and correct me if I'm wrong, I think that would probably increase our chances of it going to trial, right? I mean, if the death penalty was taken off the table.
Yeah. I mean, obviously that would be something to try to make it work to get to trial. You know what I mean?
Yes.
So all these orders are, again, the judge calling balls and strikes and like trying to preserve all the parties' rights to the greatest extent possible, both going into and at trial.
But I mean, if the death penalty was taken off the table, then what? Then how much leverage would they have to get the defense to take a plea? You know what I mean?
Oh, probably none. I mean,
That's
I
what I'm
don't
saying,
think, I think right now, just with the fact that if we're correct, right, if our hypotheses are correct and Tyler either had nothing to do or very little to do, substantially, materially to do with this, then I don't think anything's going to, I would assume Tyler wouldn't sign a plea deal on a crime that he didn't commit. I don't think we will ever know or understand all the pressures that might be applied to him. But if we think in normal terms, I think it would be hard to pressure someone into signing a plea for something they didn't do, although that does happen.
Right. Unless, like I said, then you have that death penalty on the table, and I guess maybe that's
death penalty on the table. Yeah, it can scare people potentially into signing a plea for something they didn't do.
Yeah.
I just, my opinion here is like not only the reason why we don't think Tyler had much of anything to do with it is because of evidence, right? And so I guess that was mostly informing my position on it. It's just like, dude, it's just the evidence.
Yeah, and I mean, we haven't really seen or heard anything. I mean, we've seen very little and not heard anything from Tyler since this whole thing started. But just judging by the very small amount that we've seen of him, if you take that, this is just me anyway, if you take that and also consider how his family appears to look at this whole thing, Granddaddy obviously thinks he was framed, and I'm guessing if Granddaddy thinks that, the rest of them probably do too. Mm-hmm. That being the case, Tyler hasn't seemed too overly concerned. I mean, obviously people can hide that kind of thing and whatever, but
it's because he's a callous killer and he's a sociopath,
right? Or he knows he didn't do it.
Something like that, maybe.
And has either been promised to get off or just assumes the system will work, even though it's not worked too well to this point, but either way.
Yeah, well, it's been slow and cumbersome for sure.
Yes, it has. It has.
Yeah, there's,
But to me, I would want to feel like the prosecution is losing their case at this point if I was him. So,
Yeah, and depending on, again, I think this is another question of what access to information he might have, but assuming, again, if you didn't do it, I think, obviously he should have access to the discovery and stuff like that. So I'm thinking that if and hopefully he's talking to his lawyers about, because, could you imagine, let's just assume that the Discord and texts are fake and like you're seeing this evidence and you're like, oh my God, no, I didn't do that. Like, are y'all going to be able to, call them out and get this excluded, And so, and I think too that, him going to preliminary hearing and seeing, if they do, right, and judges, and just so we're aware, I covered it the other night, the motion to, attack the constitutionality of the preliminary hearing procedures and evidence.
Yep. Based on the federal constitution.
Yeah, if judge rules against the defense and they proceed under the current structure, I could just imagine being Tyler and seeing these potentially fake messages coming in through some recorded video that Lance Twiggs did with the police.
Yeah, wait till he sees that recorded interview of Lance.
I mean, could you imagine?
And I could just see him now, like, what the hell? Those Discord messages say that they were posted at what, 8:30?
Yeah.
I know I was at the jail by 6:30.
Exactly. They got me on video. They should, right?
They should, yeah. Oh well, somebody lost that video. You guys are be kidding me. I can just imagine.
Crystal, for a second. Beep, 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 beep. Come on.
Uh-oh. What'd you do? Knock your camera wire loose?
Can you hear me?
Yeah, I can hear you. Just can't see.
Oh, wow. I don't know why. I don't know what happened. It shows that it's still on.
I mean, you're on. There's just a black square there.
I'll see if it corrects. But anyways, we have Crystal here. She goes, "Why isn't Twiggs in jail for destroying evidence or being an accomplice?" Well,
that's a damn good question.
My opinion, my perspective, again, for what it's worth, is because they need him to try to authenticate those messages.
Yeah, they probably gave him a deal, I'm guessing.
Yeah. Let me see. Yep. I'm gonna keep trying to work on getting my.
That's weird. It just went out.
Camera to work. Let's see. Hold on. Oh, technical difficulties, man.
I'm telling you. I guess it's contagious.
Do you have any access to comments over there on your end?
Yeah, so I can read them. I'm not able to bring them up, but I can read them. So, all right, let's see where we're at here. Another quick. I guess he went out completely. Gonna come back in.
I was seeing if that would help.
Black square. That's weird. Yeah. I mean, it's not something as dumb as the cable come loose or something, is it?
No, because the camera's on. I mean, I'm looking at the camera. It's just let me see if I can.
I don't know. Anyway, all right. Another question, Greg, about prosecution wanting to do another psychological test of Tyler Robinson.
There we go.
There he is.
Hey, we're back. I had to had to replug it.
Sometimes unplugging and plugging back in is the best thing in the world.
Yeah, no doubt. Did you say you had one, a good comment? Here, I'll take it off.
Oh, yeah. So there's one from Rick. It says, another question, Greg, about the prosecution wanting to do another psychological test or evaluation of Tyler Robinson.
Who does?
I missed that one. It says the prosecution
is wanting to do another test, mental test of Tyler Robinson.
Yeah, that's what he's asking about it.
Oh, I don't know. I haven't heard that.
Yeah, me neither.
I would assume they've done at least an initial one. I'll look into that, Rick. That's very interesting. I don't know. To be honest, in a case like this,
why would they want to do that though?
Well, that would mostly be geared towards mitigation.
I mean, if he came back the first time not being crazy, how could it get better for the prosecution?
Well, the reason why, I mean, in this case specifically, like if he's convicted and gets the death penalty, like if he's convicted and they go to sentencing, the mitigation part of it, it'll become relevant then, right? Yeah. Whether he has some mental disability or something of that nature would be a mitigating factor in him committing the crime. But otherwise, at this juncture, other than the allegations, I guess he was suicidal when he went in or was having some suicidal stuff before he went in. Other than that, and we saw him in the turtle suit. Presumably, you would hope that if they're putting someone in the turtle suit, that should be because a professional has told them they need to be in there for suicide prevention, or some incident has occurred that necessitates it. But so with that being said, I'm assuming hopefully if he went into it initially, we saw him, that was because there was some kind of mental evaluation. But I don't know if that's the case. I think they might have just thrown our dude in.
There's man. That would not surprise me at this point.
Yeah. And here goes Crystal again. She goes, talking about Lance Figgs, and he's not even going to give his testimony in person, which is really odd too. So there's no cross-examination. That's all. Well, unfortunately, the preliminary hearing, as the rules are written now in the Utah Constitution, Article 1, Section 12, allows that, at least at the preliminary hearing. Now, let's just all be clear. When they go to trial, Lance Figgs is going to have to show up. These other witnesses under 1102, they're going to have to show up. Okay.
Right.
This is only, at least as we know now, allowed in Utah at the preliminary hearing. Although, as we're also aware, the defense has filed a challenge. I did a live stream about a few days ago, maybe 5 days ago, about it. It is being challenged. So we might, and let me say this real quick. Judge, again, he did not comment to any real degree on the merits of that, right? That motion I just mentioned about this setup. However, Judge is already budgeting potential time for the hearing in their motion schedule, right? So he's already planning, he didn't say we're having a hearing go in this direction, but he did today include that in the allotted time moving forward. So, again, I don't want to say that's because he's going to declare it unconstitutional, and they're going to have to show up, but just to put that on your radar.
Right.
Put that on your radar there. There is some hope for due process and justice in this country.
So many things
Let's
to
pray.
put on the radar. This one.
Yeah.
Let's see.
Miss Susan says, I'm still praying for Tyler's safety in a fair trial and a good defense. He's so young. Amen, Susan. God bless. Yep. And yes, may Jesus be with Tyler in his defense, throughout this process. I mean, I could just only imagine what that young man feels like. And again, to the extent that he was involved, I hope that he pays for that. Yep. But
you read my mind. I was going to say, I want to be very clear. If he had any involvement, he needs to pay for that involvement.
That's right.
And I think that it's very likely that he did. Don't know that for sure. I just don't feel like this one lone 22-year-old kid, planned this thing, facilitated it.
Let me ask you this real quick, Adam. This might be a little bit more challenging, and what if you find out that yes, Tyler was some way tangentially involved, but that involvement was solely procured through government agents?
Yeah.
It's like, man, again.
I think they need to do like they do everything else. They need to write a sternly worded letter and then fire them, give them with full retirement benefits,
Yeah. Man, it's sad, because it's like, what if he did have some bad internet history or something, and then all of a sudden they took that to set him up to be tangentially
I think
involved,
they should be culpable.
I do too. I do too. I agree.
There's no way they could do something like that without going rogue. You know what I mean? Like that couldn't be a sanctioned type of operation.
Yeah.
They do that type of thing, and those are official, they can do those types of things officially. Yeah. But I don't think we're talking about, murdering somebody. We're talking about possibly, doing something, snitching on somebody, going undercover or whatever, they'll use that kind of leverage for that. But there's no way it could be official, like on the books, sanctioned type of thing. So, I think they need to pay. I think they need to pay just like anybody else would.
Penny Copeland says she called out Andrea Burkhart for being biased. She said no. I said she only goes on shows that think Tyler is guilty. Then
let's see the Charlie Kirk. Well, the Colvett and Neft show, and our favorite lumberjack Gary Melton.
Oh yeah.
I don't know that I've seen her.
Well,
on
he
any
does
other
beat
shows.
those flannels up, doesn't he?
I'm telling you.
Bro, he's been camping in the 50s since the 50s and shit.
You got to watch that one I did this morning. If he sees
I
that one, he's gonna be mad. He'll be mad if he sees that one.
He'll be mad if he sees that one. And then Penny goes that, yeah, so apparently Andrea, there's a big debate amongst Barron and a lot of them out there about that timeline of him turning himself in. Obviously, we covered that, having access to the phone. Yeah, and, I'll say this again. I wasn't, Gary made some pretty, in my opinion, defamatory statements about Barron.
To a damn lawyer.
I just think it was way out of line, man. I mean, I don't see Barron taking it to that level with people. Yeah, I mean, he jokes around a bit and laughs, as we would say in a more familiar, like playing grab ass back and forth, just figuratively. You know what I mean? Like, nothing. Man, I hate that it goes that way sometimes. I do.
Yeah, I mean, like, talking about a case that he lost when, like Barron said, it's still very much
it's still
alive
ongoing.
And in the appellate,
I feel that frustration too. I've had people go online and try to comment about my cases when, it's all public records. You can go on Pacer, which
that's
is
what I was
public
going to
access.
say. A Pacer search is be all it takes.
and see all that, but people just go and just say whatever.
I mean, he probably did do a Pacer search. If you want to be totally honest, he probably did a Pacer search and thought, I don't know if I'm going to frame it that way.
Yeah, if I tell it truthfully, it doesn't sting as bad.
I mean, kind of technically, he lost the first case because he did get a ruling
against the first motion hearing, so therefore we're going to say he lost the whole case. I've had that one done to me too.
Yep. Yeah, Butterbean. Gary did get him a big fat $200K contract from the DOD.
Yeah. Gary.
Yeah. You probably hadn't heard about that.
No, he got a contract with DOD.
Yeah, he got like $200,000 worth of contracts. I don't even think it was a full month after Charlie died. I think it was within a couple of weeks, about the time when he started flipping his his opinion on everything.
Surely not.
Hey, allegedly, I'm just joking. I'm just joking. Yeah, I mean, and it's not life-changing money either, but...
Well, if you get it every year, I mean, is it going to be renewed every year? Dude, if I could sign a contract tomorrow, getting $200K worth of business every year moving forward, I mean, granted, now if it took up, every single hour of my day, maybe not, but like, dude, if it's for sure money, $200K, I mean, I got some hours I can spend working on that joker.
Yeah. No shit. Nosy, Thomas Massey did lose?
Yeah. You didn't know that?
No, I hadn't. I was scared to look. How?
Dude, it's
this is the most expensive congressional race like in history.
It scares me a little bit, man. That one kind of scares me, dude, because I have a hard time believing that Thomas Massey lost. I can't
he didn't legitimately.
There's just so much at stake.
Yeah.
There's just literally so much at stake. I mean, some people have said that was the most important. I agree. It's the most important election I've ever been involved in or been, monitoring.
They're replacing a good one with another. Oh shit! What's that one fat ass's name that? In Florida, oh God, what's his name? Everybody hates him. In my mind, I know his name well. The one that Dan Bilzerian is running against. Randy Fine.
Oh, Randy Fine. Oh, that specimen.
Just a pig. Yeah.
Yeah, I just. By the way, just so everybody knows, that guy what's the guy with the gun company's name?
Penny, that was priceless. Do what now? Sorry.
The guy that we were texting about the other day, who's from East Texas, that has a gun.
Did you watch that today?
I didn't watch her show today, but I watched the episode the other day with him on there.
Corby Hall.
Yeah, he's from my neck of the woods, y'all. He's located probably.
Well, you need to go back and watch today's. You need to go back and watch today's because today she interviewed Victor Marks
Oh, no
one-
shit. Huh?
the
Okay.
one that, he's been having all the problems with. That was very interesting. I thought that they were going to, I don't know, it looked like they were going to throw down at first.
Yeah. Oh, did they?
Oh, he tried to push her around big time. But,
Wow.
Candace Owens, she don't push around so easily. So
Brett
she
Booth,
finally
why wouldn't the FBI let the defense experts in on the testing?
Well,
I mean, yeah. That's a good question, Brett. That's a good question.
Especially with a legitimate test, that's all on the up and up.
Yeah, I mean, I guess they want evidence to connect him to the scene, and they obviously need to identify a murder weapon, and obviously they've chosen the one that they've sold to everyone for $10 million is the weapon. And, when the fragment's too small and it's inconclusive, I don't know. And it's not like they've personally not cut them in. It's just like the underlying evidence, I don't think it's necessarily the experts per se who are holding on to it. But, someone is holding on to those bullet fragments and other evidence to hand over to the defense experts. Yeah, so they can do their analysis. I mean, again, we're going to enter into the land of speculation here. Okay, speculation territory. I mean, I think that they're so eager. This is just my opinion, my perspective, right? I think they're so eager to get a conviction on Tyler Robinson that, like, anything they can do at this juncture, right? At this point, I think their goal is plea. Okay, I would imagine their goal is to get some kind of plea out of him. Yeah. And so making sure that they can barrel on through the preliminary hearing without judge either substantively telling them no, your claim, or having these witnesses have to come up and testify, or the DNA bullet fragment evidence actually be contested. I think they're trying to make it through that preliminary hearing any way that they can, and they're pulling out all the stops. This is my perspective, my opinion.
In other words, they don't want any road bumps.
Because I guarantee you, their thought is that if they can get past that preliminary hearing, it'll be real for Tyler, and he'll see that we're going to take him to court. Could you imagine if we're right about all this? Again, I don't know what. If that's true, who knows what? But you got to imagine there's somebody back there who knows everything that's pushing for this innocent man, potentially, right? It's speculation to be tried and be put in prison.
And again, maybe not completely innocent of anything and everything, but innocent of the charges as
capital murder. Yeah, innocent of capital murder. Yeah, man. It just makes you wonder. There are people out there like that, bro. You gotta understand there are people out there like that can sleep and be good and eat, look at you in the face, shake your hand, doing all that.
Go home and kiss their kids.
Doing all that, dude. Damn. Anyways, let's see. I'm going through the comments.
Yeah, I don't know how they do it. Some of them.
Yeah. I'm excited about the Hunter interview. He's so erratic.
Me too.
He's going to give up Hunter who?
Oh, yeah. Candace interviewed Hunter Biden.
No doubt, huh?
Yeah, it hasn't hit yet, but it's
okay.
It's going to this week.
That'll be interesting. I'm really interested to hear, are they going to talk about the Kirk thing and like what his perspective is then on it, man?
According to her, what she was talking about it last night, I think it was, they at least do touch on it.
Yeah. Oh, okay. Well, yeah, I'll definitely watch it. Cateism, Fed GPT is still generating the data. You must have seen my X post earlier. Yeah, I was talking about that USA Today comment from the DA about the data that's going to confirm the conclusion or whatever. I said, I guess GPT or AI is generating the data for them. And yeah, Fed GPT. That's a good one. I like that one.
God.
Let's see. Hey, Dariella. Hey, everybody. Hey, I'm sorry. I usually call y'all out one by one, but God bless each and every one of you. I see you. Spyglass says, go ahead.
See that comment? I got you. Go ahead. I see where you're at.
It sounds like the prosecutors are dictating what the report should say. Definitely. Somebody's providing some conclusion that now they're getting the data and information needed to make that okay.
That's when you say, "Whoops, wrong answer."
I don't know how you interpret that. I mean, I think y'all know how I'm interpreting.
I know
that,
how I interpret it.
I felt, again, just my opinion. I felt they were going to do it. I just didn't know how bold they were going to be about it. But man, they're getting to the point where they're getting
desperate.
Government.
They're getting desperate.
Not care no longer, man.
There's no telling what's at stake here, though.
A lot.
I mean, and really, all we can do is speculate. But it's not just a prosecutor's record or image. I mean, there's bound to be something on the line that's really big.
Yeah, I mean, well, I think what's on the line, in just my opinion, speculation, I think what's on the line is the truth. And that if the truth gets to us, it's not going to be good for some people who they have a lot at stake. In my opinion, my perspective. Bree baby, we like you too. Thank you for joining us. God bless.
Yeah, thank you, Bree. Thank you for being here. Always good to see you in there.
Here goes Loomis says, talking about Massey, I'm assuming Loomis here. He did lose. I'm so sad. Goes to show the corruption. ED is a bad person. Yeah, I didn't have a good feeling about the opponent either. I think that's
ED is a bad condition. I mean, oh, wait a minute. We're talking about a person. I'm sorry.
Massey, the Massey election.
I cracked a joke.
I get it. I know what joke you cracked. You dog.
I figured that you probably wouldn't catch that one.
I did. Let's see. Oh, Penny's asking Adam Thomas podcast, how many bullets can gun hold? I guess maybe she's referring to the
that rifle, that 30-06. Yeah.
Holds a clip, but it's a bolt action. It was a bolt action though, huh?
Yeah, it didn't. I don't think it had a removable magazine. I think that it was just. I think it just held. I want to say probably 3 or 4 total.
Like you load them up under the receiver, like load them into the gun, or you said.
Yeah. That's what I'm thinking. I don't think it actually had a removable magazine.
I like those 30-30 side loaders, the lever actions, the cowboy rifles, man. Those are one of my favorite rifles to shoot. I used to deer hunt one.
Yeah, no, they're good.
Yeah. But again, 30 caliber gun, not a 30-06. Like I say, there's a lot of different rifle configurations within.
There's so many 30 calibers. It's just, it is probably the most popular caliber. Yeah. So many different variations of it.
K-tism. Prosecutor is totally rolling the dice, hoping the feds come up with something. It sounds like they're just not right. It sounds like they done talked to them. Like they
prosecutors
know.
Are like, look, we're going for broke.
From what it sounds like.
We're going for broke. Y'all just please have our backs in some way.
Yeah. I mean, I don't know what you could have said worse in terms of like, if the feds come with a new report that magically says this bullet I mean, who isn't going to be suspicious of that now?
I know. I mean, to me, it's too late for that.
Come on now. And granted, I'll say the part that we're reading in this motion came from USA Today. So it very well could have been that the reporter, because that part was kind of in their own words a bit. So maybe the reporter misconstrued it, but
yeah, there
seems to be I don't know. It seems to have been hard to really misconstrue that too far, but I could definitely be wrong.
And it's normally when they misconstrue something, when they have a snafu, it benefits the prosecution. So, I don't know.
Yeah, I don't know either, man. It's
it's funny that there's no accidental whoops, we helped the defense.
Yeah. No, that's right. It's we don't even know if it's a bullet. It could be
that's exactly right.
Metal, it could be plastic, it could be anything. They didn't even say what the material was.
Well, they did say that I think any of this is probably subject to change, but now they were saying that it was a, oh, good Lord. They had 4, I think it was 4 lead, wasn't it 4 lead fragments?
Yeah, because I think you're right. So I forget what I saw, but there was
And
some
then the other one, the bullet
document
jacket
or
fragment.
report that referenced 3 other besides the one, and maybe it'd been the report. Yeah, it referenced 3 other small.
Yeah, it was 3
pieces
maybe.
of something
They were
as well.
lead, I know for sure. They were lead
Okay.
fragments. And then on the other, I'm gonna guess if they're saying whether it's legitimately a jacket fragment or not, if it is a similar material, I'm gonna guess it's probably made out of. I'm guessing probably brass. I mean, I don't know.
Okay.
Who knows?
Well,
Probably
also
brass.
too,
But, you know,
just
like
putting
I
it
said,
out
that
there.
could be a piece out of a
Yeah.
microphone.
Yeah, well, also understand too that shape charges have a brass
Yep, they've got that cone, that brass
cap
cone inside.
or cone to them as well. So I mean, like you say, it could have been a piece of literally shrapnel. That has the same. It is the same material or composition as a bullet fragment, but isn't.
Why are we not seeing lands and groove marks on this thing?
Yeah, I
My
know. Oh man. Let's see. Crystal says, if he gets convicted, this is the dumbest jury, and it will be a testament to our education. Well, unfortunately, I mean, I do agree with you to a large extent, but at the same time,
educational system wouldn't have been the first.
It's also
place
because of our
it.
media system, right?
Yeah,
because I think they've done polling showing that like 64% of people in Utah County already think Ty Robinson is guilty because of things they've seen in the media.
I don't see how it doesn't at some point get moved out of.
I mean, I certainly think it's warranted, if and how that can occur. I don't know the intricacies there, but, at the very least, yeah. I mean, if Utah County is polling at those numbers, I don't know if they've polled other adjacent counties or other counties, but yeah, I definitely think a change of venue might be a good idea in this case, but that's just my opinion.
And nosy Google, I'm sorry, my brain, I had a brain fart earlier. Yes, copper. My God, it was right on I accidentally said brass. I don't know why I was thinking brass. Anyway, yes, a copper jacket fragment. So anyway, I just saw the comment and thought I'd say that.
Spyglass says, massage the report to benefit the prosecution.
Yep.
Oh yeah, hey. And maybe I said this last stream, maybe not, but I thought about this the other day. A lot of times you'll hear police officers and, federal agent stuff like justify violating someone's constitutional rights because they're a criminal. It's a criminal.
Yeah.
It is a criminal.
Yeah.
I mean, we caught them. I mean,
So what if we got to cut some corners?
Yeah, I just encourage people, like I said, the way I see that is like in terms of our country and laws, like the Constitution's like the 10 Commandments. You know what I mean?
Yeah.
It's like one of those things that like you really shouldn't have any sacrifice on.
Well, look, the way I interpret it, and I feel like it's pretty clear. The United States Constitution, I feel like if you actually take it at the obviously the letter of the law, and I mean, but you look at the spirit that it's, was written in, and what their true intentions were. I feel like as bad as it would be for one guilty man to get free, at the end of the day, it's better for a guilty man to go free than for an innocent man.
It really is. I know it's hard for a lot of people, but it's like,
at least the guilty man is going to pay in one way or another sooner or later, even if it's after this life.
That's right. Yeah, because it's like if you're guilty and get off, like the cops know what's up. You know what I mean? Like they're going to be on. So it's either you're going to have to straighten your ass up.
That and you got to meet your maker one day too. So
pay the price.
Yep, you got to meet your maker one day too. But if you, especially talking capital cases, like if you were to take some, and they've done it. Trust me, there's been plenty of innocent people that have been killed,
Oh, what? Yeah, dude.
Put to death, over the years. And to me, that is just so much worse than.
Think about, man. Like, that's the thing. It's like That would be the hard. I couldn't be I would be a good prosecutor. I'd be a good investigator. You know what I mean? Like I've been in and out of the streets for a long time. I would be really, really good, but like either being forced to go after someone who's not really doing anything deleterious to society in any real sense to me would be hard. And then just the thought that I would be involved in something where someone innocent or, you know, or punished way more than they should. I don't want any part of it. I just don't want any part of it. Not even the possibility. I don't.
Right.
Yeah, man. Let's see, cases. So they have is the summary report talking about the expert reports. Yeah, my impression is that they're just summary.
No underlying, you know, information that shows how the data was.
Yeah, basically the actual items, right? So like with the ballistics report, you have the report, but and they also talk about the DNA. Like even those reports are missing evidence as far as like
you have to know how it was collected,
and,
how it's collected, and exactly what testing. How did you come to this, you know, conclusion? Because something like that, trust me, very, very easily, you know, messed up.
Yeah.
Or, you know, even, you know, purposely put in one direction or another. When you're talking about something as minute and something as technical and something as, you know, as DNA, I mean, like, come on. It takes almost nothing to completely,
Yeah. Nosy Google. They're talking about the text messages and Discord messages here, talking about the metadata. Nosy Google saying they better have metadata for all messages for it to be evidence.
Yep.
So this, under the rules of evidence, what you bring up is what we call authentication, right? Proving that these items of evidence are authentic, meaning claiming what it you know is portrayed to be. For, you know, like these are Discord messages from Tyler Robinson. These are text messages from Tyler Robinson. You make a good point. Now, as it stands at this preliminary hearing, I think judge will consider the text and the Discord messages just based upon, unfortunately, Lance Twig's statement that, hey, these are messages from Tyler Robinson. Now, when it goes to trial, I would be very, very surprised. I would be kind of upset if judge lets those messages in without the metadata.
For sure.
Meaning that, you know, because you have to prove, you know, ultimately the jury makes the call on whether it's authentic or not, but judge makes a preliminary determination whether it's admissible. And part of that is there enough basis here for the jury to believe these are authentic?
And we're not talking about metadata from like the local device where you just go in there and you click, you know, the info and details, like actual authentic metadata, be it from the cell carrier or wherever, you know what I mean? Like, because I think there's layers to the metadata, you know what I mean? Like I know that I can go into a picture right now and change the location and day and time. But if I understand correctly, there is another version of that is out of reach. You know what I mean? Like, that can't be edited that way.
Yeah. So I'm hoping judge, at the very least, when it comes to trial, will require, you know, that these things be proven up in the metadata. And then obviously we know too that, you know, at least with the Discord messages, I subscribe to Barron's timeline and interpretation of the documents and events that they also have that defense too, attacking whether this was even possible. I mean, I'm assuming that they do have Tyler on camera at those times. If he was, you know, since he was in my opinion there.
For some reason, that just wasn't publicly available. The guy that said that it was deleted just didn't know what he was talking about.
So we could run a due process.
Somebody does have it.
If that's true, if Tyler was in the police station, his contention is I didn't have my phone, was not on my phone at that time, or have access to my Discord, and they don't have the video, then that would be another good place. If they claim they destroyed it or lost it, then that would be another great due process challenge.
Oh, yeah.
Due process challenge, because the failure to preserve that evidence, obviously, if it's true that he's on video, not on Discord, well, that's obviously directly exculpatory evidence as it relates to those Discord messages. And so the prosecution, in my opinion, would be really under fire in that situation and possibly could face some pretty severe sanctions if that's true.
So if by chance Gary Melton is correct, and I think that he's sadly mistaken, but if by chance he is correct and Tyler did have his phone the whole time he was there waiting, then like you said, yes, all of that should have been recorded and should be easy enough to pull that footage to see if he got on Discord and posted messages while he was sitting there.
Yeah.
Either that, the other option is he didn't have his phone, which means he couldn't have done it.
And obviously the analysis would be the exact same in Utah as it was because I've done a stream about the paving over the crime scene, but it's basically like this. Tyler's attorneys would need to come to the court, file a motion and say, look, we believe this evidence that has been admittedly lost or destroyed by the state, that there is a substantial probability that it would have been exculpatory, meaning, again, tending to show Tyler's innocence. And so they would need to make an initial showing in that regard. And then if they do it, then it'll kind of switch and the judge will look at, well, is there other evidence of his guilt that's substantial that, even if this was lost or destroyed, it wouldn't really matter because of the other evidence. And then
you got something to offset that.
Yeah. And then what if there's not, then they're going to look at, well, what level of culpability, meaning what level of fault can we assign to the prosecutor and the investigators here in the police in not preserving this evidence? And then they would determine from there, like, do we need a jury instruction where they're to assume that this video that's not there would have been tending to show that Tyler didn't do these messages. So that's the analysis that would run, but it would essentially be the same as, again, on any of these evidence, including where they paved over. It's easier than the crime scene paving over because they can identify what specific evidence was destroyed. Whereas with the crime scene, we're really assuming in a lot of ways that I think very fair assumptions that there was, material evidence, whether it had been exculpatory. It's just a harder analysis than the messages in this video, really, right?
I mean, that's pretty straightforward. I mean, either he had access or he didn't have access. And even if he did have access, there should be video footage of him doing it if he did.
Yeah.
I mean,
Yeah. K-Tism makes a good point here. They're not as strict talking about the courts. They're not as strict about what they allow in a preliminary hearing compared to what's allowed in trial. Absolutely. Very astute observation there. Yeah. And I think a lot of people get that mixed up. Like, the preliminary hearing is just probable cause hearing. Burden's really low. It is on the state, but it's really low. They'll allow in evidence that might not be fully admissible, at least right then in that form, just to kind of get a feel for what might be presented at trial. So, it's completely more relaxed, and especially on the prosecution in these preliminary hearings.
Yep.
Let's see.
Yeah. Let's see. Lots of good comments, though.
There are.
Guys, thank y'all for showing up, turning out. I
hate
to
what are your thoughts? Do you think
so
Tyler's defense is for him or against him? I to be honest, I'm tending to think that they're actually for him. I do.
They've got to be. Look, these people, these are not just regular run-of-the-mill public defenders. Like we talked about before, Catherine Nestor is a very, very, she's been a lawyer for a very long time, very highly decorated, done some, really big cases. What could anybody offer you at this point in your career for you to just, throw it all away?
Yeah, a lot of the stuff that I one time had suspicions of, like them keeping that report private and January 9th motion stuff like that, a lot of that was actually resolved today. I came to understand now why they were doing that, trying to comply with judge's order and be within the rules. Right. And so, I felt at one time maybe that, but as time's gone on, I've looked at more of their pleadings and the cases developed. I now have a much more firm understanding of their strategy, what they've been doing, stuff of that nature. So I'm tending now to think that they are working for him and doing it competently. Now I do believe that.
Well, yeah.
Good question though, and I get it. I mean, with the way this case has gone, y'all, I don't fault anybody for having suspicions of damn near anybody.
Good
Their own
God,
mama
I'm
being
telling you.
involved in all this, man. It's
I'm
like,
telling
wow.
you, it's crazy. They don't make them like this every day.
Yeah. Let's see.
Somebody got a super chat.
Super chat. Who's that? Okay-tism. What's up? The fact that they paved over the crime
Yeah.
scene should be case closed. I mean,
Yeah.
I certainly agree. I mean, and man, and if you want to, Kate, I did a live stream on this. I actually think I did more than one talk. I've talked about it a lot, but yeah, I mean, looking back at the only thing that, and I pointed this out to Adam earlier, that makes it a little bit difficult on the due process for that is just the Tyler and them would need to identify like the specific piece or kind of evidence that
What
was
is it
destroyed.
that would have been destroyed?
Yeah, and then connect how that would have been exculpatory. And, you know, I hate to think that, like, well, man, it's kind of like their bad behavior there prevented them from making that due process. I hate that. I agree. And was that part of the thing? You know.
Yeah, and I mean, look, at the end of the day, and this is what a lot of people just got to come to terms with. I kind of have. It sucks. Legally, I mean, I just don't think they did anything wrong. From a practical, standpoint, from just a good common sense practice, if you were truly, I think if you were truly, if this was a real investigation, I think they would have wanted to leave that available in case something came up later and they wanted to go back and test.
Yeah.
It almost makes you feel like they wanted to make sure that couldn't be done. But did they break any laws? Did they pave over it while it was still under, while it was still under law enforcement, No, technically it was no longer a crime scene. I mean, they released it. They did what they had to do. Pretty suspicious, but,
Yeah. Now, I think that if Tyler's attorneys could, in some way, argue that or come up with some type of evidence or indication that, no, there were other maybe pieces of bullet fragment there or, something that, again, and I don't want to go into a whole host of possibilities, but, latch on to something and say that would have been there, and based upon maybe other evidence, whatever, like would have been exculpatory. And in that case, I mean, I think just because of the boldness and embrace, you might be bordering on case dismissal type stuff.
I mean, look, to do it on a
very well
daggum Sunday of all days. I mean, like, come on.
I know.
It not a Sunday? I'm pretty sure it was done on a Sunday.
Yeah.
That
just it was. I'm
seems
almost sure it
desperate.
was. Here goes in his image 777. I like that name. If the DA tries to use the Discord messages, he should be charged for false imprisonment, crime evidence. Well, hey, to the extent I'm going to premise mine on this that to the extent that they are aware that was contrived or manufactured, yeah, absolutely. Absolutely. There might be the instance where like the feds did all that and then handed it to them. Like, here you go. Again, there's speculation, but I could see that situation too. So I don't want to say like, if they try, they got to go to jail, but depending on their level of knowledge.
Yeah.
We all got to pay the piper one day,
Yep. That is true.
Let's see.
Some sooner than later. Boy, this is a lively chat. I'm loving it.
There's a lot of people in the chat.
I love to see it hopping like that.
Oh, here goes Free Baby. Jesus is always listening. Amen. Don't give up on him. That's all I have to say, and I'll leave it there. He loves you. He wants a relationship with you. Amen.
There you go.
Thank you, Bree.
There you go.
The type of comments that we need. Let's see.
Yeah, Bree's awesome. She let's see. Mystic. You know Mystic, don't you?
I do know Mystic. I haven't seen her in a while. Seen him in a
Yeah.
while.
Yeah. Bree's good friends with her, I guess, and they do some modding and Mystic Center over one day, and she's been hanging out ever since.
Let's see. Oh, here we go. The MK Ultra is a lot more than some wacky psychedelic drug.
Yeah.
Yeah. It's like, dude, it's like every day I learn more and more about this stuff. It's like, man, it's insane. Yeah, I had an LSD case one time in federal court, and just was anytime I get a case, criminal, civil, whatever, I'm always thinking jury, trial, jury. So I'm like asking people I meet and encounter just various questions about the issues that might come up. I'm just getting opinions, And one thing I found is that, man, your average U.S. citizen who is aware of MK Ultra is not happy about it, and I've had a lot of people tell us like the only bad thing about LSD is when the government gets their hands on it.
Right.
So yeah, it's funny that you brought that up. Yeah, people are upset about. I mean, rightfully so, and especially.
And never mind the fact that the CIA went in when the government was on shutdown and pulled 40 boxes of documents out. On MK Ultra and some other stuff from the DNI.
Yeah.
About that story.
The office raid.
Yeah.
Man. Damn. Yeah, I still can't believe about the $200K contract with who verified that. I assume they went online and saw.
Yeah. I can send it to you. Yep. And listen here, one of the purchases of all things was for night vision goggles. Why in the hell would the United States military, buy night vision goggles from Gary?
Does he?
He's not a No, that's what I'm saying. He doesn't manufacture them. I would think that his inventory would be very limited compared to what the U.S. military would need. Well, this doesn't really make a whole lot of sense.
No. I mean, so I'm wondering. Going to go down there.
It got my gears going too.
Just because, I'm just thinking, so where would you originally even acquire these goggles from? Some kind of surplus or something? I mean, it's like, seems like a circular thing almost, maybe to me.
Right. Yeah. I mean, some type of true military grade. I mean, they're not general. I don't think they're generally available to the public. So,
yeah,
I don't know.
I think Catism is referring to the Thomas Massey thing here, because they have the age 65 and up Fox News demographic on lockdown. Apparently so, dude. Wow.
Yep, for the most part.
And thank you, Virgo. I appreciate it. God bless. Always good to see you. Hope life's treating you well.
Yes, good to see you here.
Let's see. I'm hoping Massey runs for president, to be quite honest with you. I don't know if I'm going to get out to vote for anybody else to be.
I know.
Clear up with y'all. And
you know what? Maybe that's the best thing that could have happened to him, is losing that race.
I hope it motivates him.
Because if he stays in Congress, I
think he's presidential material. I really do. I think through and through. Like a breath of fresh air. Like I agree with Massey on stuff, but it doesn't even matter to me. Like, I just like Massey. I trust that whatever he does, he's sincere, and
that's the whole thing about it. Even
that it's the best thing.
I might not 100% agree with it, but I feel like it's going to be in good faith.
I'll suffer through some stuff for a man who's got goodwill and integrity and doing what he thinks is right. You know what I mean? Let's see. Well, I'll probably get off here in a minute, y'all. It's 11 here. I need to.
Yeah, it's getting late. I shot myself in the foot. I could have got me almost another hour of camera
what happened?
time.
Oh yeah.
Just all the technical difficulties trying to get on here. Yes, it's frustrating
when you need it the most.
Yep. I don't know what it is, but I don't know if I'm every time I'm on as a guest, it seems like there's some dumb problem. And why I don't, well, I guess it is a different browser. See, normally I use, actually, I don't know. I think it is a different browser. Oh yeah, Edge is what I normally use. And
okay.
Yeah, whenever I get the email, it always opens up in Chrome. I need to remember to start opening it up in Edge instead of doing the default to Chrome. Rick said it's 1 p.m. there. Yeah, you know he's in Australia, don't you?
Yeah, I tell you, I was trying to get Rick a membership the other night. I was trying to get Rick a membership that way he could show up to our thing on Sunday, which I'm gonna get him one this week. But dude, I didn't realize like if you either buy or you actually get YouTube lets you give out, I think, 10 free memberships a month. So I was like, oh, okay, well, I'll just give out free ones. Rick will get one.
Yeah.
It doesn't let you pick. It just randomly
They got to be random. Yeah, I remember hearing that.
Oh, we pick your biggest supporters and stuff. And I mean, nothing wrong with the people who got them. I'm blessed for them. But it's like,
yeah. But still,
in all fairness, has been like one of the day one people here.
Yeah.
Get one. So we're gonna work the system and get him a membership so that way he can come in on Sunday. And then I'll get you one too, Adam, next time.
Yeah.
We get the. But anyways, I'm sitting here looking in the comments. Look, I love y'all. I'm gonna go grab a bite to eat and catch a video and lay her down for the night. But I had a good time, and it sounds like everyone got a lot out of it. I'm glad. I'm continuously catching up on these pleadings and getting my feet back up under me with the court proceedings. So moving forward, a couple times a week, I'll be doing videos on that, and then meeting with Adam. I think Barron's off all this week, so maybe we meet up again Thursday. And just let him do Friday this week or something. If you want to.
Well, and if nothing else, I mean, as far as I know we may not have anything hammered out as far as topic and all that, but I'm assuming we're still planning on going live with Matt this Friday night.
Yeah, I'm good with that. Yeah, I'm good with doing live streams on this channel pretty much any night, man. I mean, with a day or so notice, we can definitely do that. So just I'll contact you about Thursday, and then we can do Friday. I can help generate some conversation stuff if I need to. Just let me know.
Yeah, sure thing.
Yeah, man.
Definitely. I know everybody loved that last time that we all
it was good, man. I had a good time.
I always have a good time with Matt.
I do too.
He's a good one.
I do too. I do too.
Y'all guys, make sure y'all subscribe. Look, when I started, maybe the number's gone down some, but when I started tonight, I think I lacked 38 to making it to my 500, and then some watch hours. So
how many watch hours do you lack?
800, I think, was what it was roughly the last I saw.
Okay.
Out of 3,000.
Okay.
So I'm getting there. I think I was at 461, 462, something like that.
You get credit for this?
Yeah.
Okay.
Yep.
Good deal.
Well, any of them that are on my channel, I will.
Okay.
So,
so we'll switch back next time then. I didn't realize that. We'll get you there. Yeah, we're gonna get you there.
There's several I've noticed that don't have the little paper clip on them. So as far as I know, those without that little paper clip are watching on my channel. So it is what it is. But and y'all guys can always go back and replay crew.
Yeah, absolutely. Yeah.
So, yep. All right. Well, anything else? If you go to the description of my video, I got my 3 super chat links there. Venmo, Cash App,
yeah. Support Adam. He's a hardworking man like we all are. God bless y'all and thank y'all. And go subscribe Adam Thomas Podcast. If you got enough bandwidth, come back.
Yeah, help me get to the 500.
We will be back.
Yep, absolutely.
Cool.
All right, guys. See you, dude.
All right, brother. Much love, man. I'll see you soon.
All right.
All right, brother. Peace.